Hello, everyone. Welcome to Court with Krissy. What do these four defendants have in common? They don't want a lawyer. It's bad for them, but it's good for you. And it's going to get me some views. I hope you like it. Court with Krissy is now in session.
Good afternoon. What's your name, sir?
I'm Joseph Allen Tropt II.
Thank you very much. Let's see, Joseph. All right, so this is number 13 on our calendar, cause number 24L001203, the City of Lakewood versus you, sir. Can you please state your full name and date of birth for the court?
Joseph Allen Tropt II.
All right, thank you very much, sir. You've been charged by way of complaint with one count of assault in the fourth degree domestic violence. This is a gross misdemeanor, meaning it is punishable by up to 364 days in jail and up to a $5,000 fine. I had an opportunity to review the statement on probable cause, and I do find it's been established for purposes of this hearing. I'll ask your attorney to please acknowledge receipt of the complaint and enter a plea on your behalf.
Okay.
Your Honor, Ansel Verwath, appearing on behalf of the defense. We were told that he refused to speak with attorneys, so we have not spoken with this individual. I will
Okay.
acknowledge receipt of the criminal complaint, but either he's going to have to make a plea on his own behalf and waive attorney, or I would need to speak with him.
All right, sir, do you wish to speak with an attorney?
Sure, if I need to. I can't speak very well. It's kind of a backwards story, and I'm not sure what happened at all because I have quite a bit of injuries and I'm dealing with it pretty rough.
I don't want you discussing the case because you could damage your case.
Okay.
You'll need to exit the room right now and speak with a lawyer before we can address your case, okay?
Why is that?
Because you need to, if you're going to speak with a lawyer, then you need to be able to speak with them in private.
Well, can we just carry on here?
Well, no, because then we have to do a waiver of counsel form, and you'll need to speak with a lawyer to fill out the waiver of counsel form.
I don't understand. I'm sorry.
You just have to talk with a lawyer, sir.
I don't understand though. I
Okay?
can't talk very well.
I think that you speak very well and very clearly. Okay? But you do not want to make choices that marginalize your future. And speaking with a lawyer is a very good choice at this point, sir. Okay?
Okay.
All right. So please step out and speak with an attorney.
Oh, they'll speak with me here today?
Yeah, on the phone.
Okay,
here
okay.
today,
I
okay?
wasn't understanding, sorry.
Your name is Mr. Marvin, is that correct?
Michael Jack Marvin, yes, Your Honor.
Okay, so this is People versus Michael Marvin, case number 245339. The record should reflect that Mr. Marvin is present here in the courtroom today.
Sierra Coke on behalf of the people.
So, Mr. Marvin, it looks like this is your first appearance here in the circuit court. You're here without an attorney. You understand that you have the right to have a lawyer?
Yes, Your Honor.
Okay, and you understand that if you can't afford a lawyer, one will be appointed for you at public expense?
Yes, Your Honor.
Did you wish to request a court-appointed attorney?
No,
You want to represent yourself?
correct, Your Honor.
Okay. So I'm going to go through some things with you with regard to that, okay?
Yes, Your
First of all, have you ever represented yourself in court before?
No, Your Honor.
Have you ever received any legal training or have you had any experience?
No, Your
Honor. Have you ever, do you have any kind of a legal degree or other degree?
No, Your Honor.
Okay. So I want to make sure that you understand that without any of that kind of training or experience, that there are certain risks that go with representing yourself. there are issues regarding procedure in the law that you might not know about, and you might not follow some of the rules that you're required to follow, and that could hurt your case. Also, things about the substance of the law. In other words, there might be some legal defenses or arguments that could be made on your behalf that you might not know about without having an attorney to advise you on those things. Also, the consequences, you know, what kind of penalties that you could face and what your options might be. An attorney could help advise you of all of those things. And so without having that kind of advice, you could have a worse outcome in your case. Do you understand all of that?
Yes, sir.
Knowing all of those things, did you still want to represent yourself?
Yes, sir.
Okay. So I find for the purposes of today's hearing that your waiver is knowing and voluntary and unequivocal. In other words, you're sure that that's what you want to do?
Yes, sir.
Okay. So all of that being said, Ms. Koch, have you had any discussions with Mr. Marvin? Have there been any plea offers?
Yes, to both of those. The plea offer was to the drunk driving third, dismissed the additional, the RNOs and the open intact charges. Mr. Marvin wants to have a trial. I talk to Mr. Marvin at least once, sometimes twice a week, maybe more. And he is considering filing a suppression motion. I sent him the blank SCAO motion, told him, I can't give him legal advice, but procedurally, this is how you file a motion if you want to. We talked about, he wants to have his wife come in and testify that he has a habit of driving places and then getting drunk at those places, and she comes and picks him up. I advised him if he goes down that road at trial, that I'm going to ask that his prior drunk drivings come in. They would not come in otherwise. So, you know, opening the door could be bad for him, and he should have an attorney. I advise him regularly that he should have an attorney, but he doesn't want to. He also discussed the reason marijuana was in his system. And I told him that's probably not relevant, and I would object if he tried to bring that up in trial, because it doesn't really matter why he had the marijuana in his system. But we went over those issues. I think we're ready for trial. I'd ask the court to set the trial, and if he files a suppression motion, we can run it. We already ran a preliminary examination, and I think he did a request to get the transcript today, so we can go from there.
Okay. And just because so this is based on intoxication involving alcohol, that
Alcohol and marijuana.
all right. So Mr. Marvin, is that correct? You wanted to proceed to trial?
Everything she said is correct. Sir.
All right. So Ms. Koch, you said how much time to be ready for trial?
We can set it out like 60 or 90 days, depending on the court schedule. And that would give him time if he decides to file that motion to suppress, to do so.
If I set this for trial in 90 days, is that enough time for you to be ready?
I would tell you, Your Honor, that I'd like as much time as I can. I don't feel like I'm going to have an issue as far as bond conditions or anything like that. And I don't have a secretary. You know, I've never done this. I'm learning every day as much as I can. And I do understand that I'm a one-legged man in a race against an Olympian. I understand that I am not going to become a lawyer by Googling it. You know, it is going to, but the more time that I can have, the more prepared I can be. And like I said, I don't see an issue with anything to where that would change. And I am not requesting a speedy trial either.
Okay. All right. I think, 90 to 120 days is probably what we would be looking at. So we'll set it out at that period.
Thank you.
Ms. Koch, how many days on trial?
1.
Besides yourself and possibly your wife, do you have any other witnesses that you would be calling?
I did have a question about that, Your Honor, and that's my brother, who I had talked to on the phone that day, would like to know if he could write just what we talked about and not be present. He has fear of coming in, of repercussions, to be honest, and he would write that as well if that was necessary.
That's not typical. Usually witnesses have to be here in person to testify.
Yes. Okay.
You could certainly try that. I suspect Ms. Koch would object, and I'd have to make a ruling on it.
Fair enough.
So I can't tell you yes or no sitting here right now.
Yes, sir.
Because she could agree to it for some reason. So
Yes, sir.
that's a discussion that you should have with her.
Okay.
And if you want to introduce that kind of handwritten testimony at trial, again, I'm sure she would object, and then I would have to make a ruling at that time.
Yes, sir.
Okay, so I'm going to set it for a one-day jury trial at about 90 to 120 days out. And so, Mr. Marvin, you'll get a letter from the court that gives you those that trial date once we have that. I'm also going to set it for a final conference, and that's just one more opportunity for us to be in court to address any issues prior to trial, and to the extent that you would want to consider any other or different plea offers, that would be the final date to do that. And then also the final date to file any motions. So that final status conference, you're going to get two different dates. You're going to get a date for the final status conference
And then one for the court.
for the trial.
The trial.
So that final status conference, if you have any motions, they all need to be set for hearing no later than that date.
That'd be for evidence as well, to get evidence in. or-
Yeah, any kind of motion that
Okay.
you would want to file.
Yes, sir.
And you're also going to get a copy of the scheduling order that explains to you all of those things.
Okay,
as well.
thank you.
And then there's also some instructions in there about providing witness lists and those kind of things. So just make sure you read through that, okay?
Yes, sir.
All right, Ms. Koch, anything further that we need to address for the record from your side?
I will amend the information. We did just get the marijuana lab to say intoxication by alcohol and or marijuana. And I'll send a copy of that to Mr. Marvin, and we can discuss any questions he has about the procedures that you set forth today. He'll probably email me.
Mr. Marvin, anything else I can address for your side?
No, sir.
Thank you, that's all for today.
Thank you. Thank you.
All right, is he there handy?
Yes, sir. I'm getting the camera turned around.
Okay, let's take that one up first. You're Christian Batson.
Yes.
All right, this is the first appearance docket for Butler County, Kansas, November 6, 2024. First case we'll take up is State of Kansas versus Christian James Batson, case number 24 CR 410. The state appears by Devin Canfield. Mr. Batson appears in custody from the El Dorado Correctional Facility. Mr. Batson, you're here for a first appearance. Do you have a copy of your charges?
Yes, I do.
All right, there are two counts, both alleged to have occurred on September 9th, 2023 in Butler County, Kansas. Count one alleges that you did knowingly cause great bodily harm to another person or disfigurement of another person, to wit, Joshua Allen Johnson. That is aggravated battery, a level 4 person felony. Count two alleges that you did knowingly cause bodily harm to Herschel Alfonso Kemp with a deadly weapon or in any manner whereby great bodily harm, disfigurement, or death can be inflicted, to wit, handmade stabbing device. That is aggravated battery, a level 7 person felony. Do you understand your charges, Mr. Batson?
Yes.
All right. Can you afford an attorney to represent you?
I'll be waiving my right to attorney and representing myself, sir, juries.
All right. You understand that if you can't afford to have an attorney, one would be appointed for you?
Yes, I understand that.
And knowing this right, you wish to represent yourself?
Yes, Judge.
All right. At the correctional facility, do you all have a waiver of counsel form by any chance?
I've already wrote out the motions for discovery. I'd also like to request a 90-day speedy trial. So I have the motion wrote out for that, and I'll be sending all the motions as soon as I get them notarized.
All right. Well, I'll note here on the record that you've waived your right to an attorney and you wish to represent yourself. Since this is a felony case, you won't be asked to enter a plea today. Your case is going to be assigned to Judge Hart. Your next hearing will be on his felony preliminary hearing control docket. That will be on January the 6th at 2:30 in the afternoon. and that'll be done by Zoom, January 6th at 2:30.
Okay, down where you wanna go?
It's already up there.
All right.
All right, Mr. Canfield, what's the state's recommendation for an appropriate bond?
Your Honor, the defendant is currently in correctional facility on Casper. It shows the earliest release date being 2050. So the state's recommendation would be a 50,000 OR at this time.
All right, I'm gonna set bonding the amount of $50,000, cash or surety. All right, Mr. Canfield, can you think of anything else we need to do with Mr. Batson's case this afternoon?
No, Your Honor.
All right, Mr. Batson, do you have any questions?
No, I do not.
All right, if there's nothing further, we'll be in recess. You are excused. Thank you. Case number 24 CR 479. State appears by Brett Sweeney. Mr. Fagan, do you have counsel yet?
Not that I know of.
Okay, Mr. Fagan appears in pro se from the Butler County Jail. There was a first appearance done on October 21st. At that time, bond was set at 3,000 cash or surety. Mr. Fagan, according to the docket notes, announced that he'd be hiring his own attorney. It was set over to today. So, Mr. Fagan, you haven't been able to hire an attorney?
No,
Okay. Are you still wishing to represent yourself, or do you wish to apply for court-appointed counsel?
I'll represent myself.
Okay. Do you wish to hire an attorney still, or can you?
I'll do pro se.
Okay. Now, this is a serious felony case. You understand that if you can't afford to hire an attorney, one would be appointed to represent you?
I understand.
Okay, and I'm gonna need you to sign a waiver of counsel, if there is a form there. There at the jail, do you have a waiver of counsel form?
Believe so. I'm trying to find one. Ha ha. Yes, I do.
All right, Mr. Fagan, if you could read over that waiver of counsel form, ask me if you have any questions.
I can see it again. They've never showed me my charges, so where's the charges at?
You had a first appearance on October 21st in front of me, and I went over your charges with you.
Nobody ever gave me any charges. They just had me in court here, and they were supposed to take me to Wichita and let me go from Reno. Yeah, this case was done in Reno County by Judge Newsom.
I don't know anything about that. I know you were here October
And they
21st.
dropped the charges. Yeah,
I don't see,
I don't even know what I'm doing here.
because you have pending charges. If you could have a seat, please.
Oh well, but I hadn't. Yeah, if you guys never showed me the charges,
All right.
I need a paper that has the charges on it with it notarized and everything else to show me the charges.
All right. I went over your charges with you. Are you saying you didn't receive a copy of that?
Yes, I am.
All right. Well, there at the jail, do you have a copy of his charges by any chance?
No, Your Honor, I do not, but I can probably track them down.
Okay. If somebody can get him a copy of the charges, do you need me to go over those with you again, Mr. Fagan?
Yes, sir.
All right. There's 2 counts, both alleged to have occurred October 20th, 2024 in Butler County, Kansas. Count 1 alleges that you did unlawfully possess an opiate, opium, or narcotic drug or a stimulant designated in subsection D1, D3, or F1 of KSA 65-4107 and amendments thereto, or a controlled substance analog thereof, to wit, methamphetamine. That's possession of methamphetamine. That is a level 5 drug felony. Count 2 alleges that you unlawfully possessed, or you did unlawfully use or possess with the intent to use any drug paraphernalia, to wit, tin foil, to store, contain, conceal, inject, ingest, inhale, or otherwise introduce a controlled substance into the human body. That is possession of paraphernalia for use. That is a Class B non-person misdemeanor. So those are your charges, Mr. Fagan. Do you still wish to represent yourself, or do you wish to hire an attorney, or
So where are they saying this happened at? Yeah.
in Butler County, Kansas?
They brought me here, yeah, from Reno, yeah.
You're in Butler County.
Okay, well, you'd have to show some kind of video footage or something like that of me doing that, because I'm saying I didn't do that, yeah.
Okay,
And
well,
I haven't signed anything, and you haven't showed me any charges that say that's on there.
all right, I've gone over your charges. Do you wish to hire an attorney, represent
I
yourself?
can't hire an attorney if I'm not working.
Okay, do you wish to apply for a court-appointed attorney?
No,
All right, you wish to represent yourself then?
no.
Well, it's got to be one or the other.
Well, I'm not signing the deal, and I'm not pleading to charges I haven't done, and yeah. You guys can't just have me on camera and say I did charges and charge me with something I haven't done.
Well,
It's illegal.
okay. I'm going to set this over.
Because I've never done an opiate. Only thing I've ever done is smoke weed. And I've never had a drug charge anywhere in this state or any other state.
I'm going to appoint James Watts to represent you. He's an attorney here in El Dorado. And I'm going to set this over to December 30th at 2:30, back on this preliminary hearing control docket. He'll be able to answer questions you have about the case and any defenses you may have. He'll be able to discuss all that stuff with you, Mr. Fagan. They'll be able to give you his contact information, and he'll be notified that he's been appointed.
Is this gonna be a Zoom or in person, Your Honor?
It'll be Zoom, back on this same docket, December 30th at 2:30. Or let me make sure, is Jim going to be back in time to do that docket?
He said he'd be back that day.
Okay, he's already got a couple on there, looks like. All right, bond's already been set. All
I
right,
have this charging docket, Your Honor.
okay, you have the charging document?
Yes, Your Honor.
All right, if you could please provide that to Mr. Fagan. All right, there's a copy of your charges, Mr. Fagan. Mr. Sweeney, anything else on the Fagan case?
No, Your Honor.
All right, Mr. Fagan, do you have any additional questions?
No.
All right, we'll be in recess. You are excused.
The back page is Mr. Watts' contact. And I believe that's all I have here, Your Honor.
All right, thank you very much. Have a good day.
Thank you.